Good morning. I'm going to call this workshop to order at 9 a.m. For the record, I am Mark Voloshin, Deputy Secretary of State for Elections, and I will be conducting this regulations workshop today. First and foremost, if you are interested in participating this morning, you can call 1-888-475-4499 and then provide the meeting ID number 893-8243-9854. Again, that is calling a number 1-888-475-4499 and then providing the meeting ID number, which is 893-8243-9854, and then pressing pound when prompted for a participant ID. At that point, please press star 9 to take your place in the queue. Agenda item 2, public comment on matters not on the agenda. Comments will be limited to 2 minutes per person. Is anyone interested in participating and providing public comment about a matter not on the agenda today? If so, please come forward, identify yourself, and spell your name for the record. We'll start first here in Carson City, then we'll go to Las Vegas, and then we'll check on the phones. Seeing no one in Carson City, seeing no one in Las Vegas, broadcasting, would you be able to check the phones, please?
To provide public comment, please press star 9 to take your place in the queue.
Good morning. Matthew Winterhawk for the record. Chair and members of the subcommittee, I thank you. Speaking today on behalf of Nevada parents and children who cannot be here today because they're at work, caring for family, or navigating their daily responsibilities, not because they don't care, but because participation itself has become a luxury. I want to be clear and fair on the outset. I'm not here to accuse anybody or assume any bad intent. I recognize that proposed regulations are framed in procedural clarifications and standardization efforts. That said, procedures are where trust is either built or quietly lost. The proposed changes that are expanding today centralize the authority of Secretary of State over election-related complaints, voter status notifications, and ballot processing standards. While none of this changes how a Nevadan casts a vote today, it does change how concerns are raised, reviewed, and resolved. Parents teach their children that if something seems wrong, you speak up, respectfully, clearly, and through proper channels. When complaint processes become more complex or discretionary, the burden shifts onto citizens to prove not just a concern, but now their worthiness to be heard. On voter notices and inactive designations, I urge caution in communication. Many Nevada families move frequently, rent, or rely on inconsistent mail service, and an inactive label, even if voting rights remain intact, can discourage participation if it's not explained clearly and repeatedly. And regarding ballot postmarks, while I understand the operational necessity of using USPS barcode data, systems the public cannot see must be matched with transparency that the public can understand. So my requests today are simple, 3 of them. Clarity and plain language explanations accompany any procedural change. That dismissal authority be exercised narrowly and heavily documented, and that the lived reality of Nevada parents and children be considered when administrative efficiency intersects with civic confidence. Trust in elections is not built by asserting authority. It is built by demonstrating fairness, consistency, and accessibility. Thank you so much for your time, and Happy New Year to each and every one of you.
If you have recently joined the call and would like to provide public comment, please press star 9 now to take your place in the queue. We have no more callers for PC.
Thank you, broadcasting. Now we will move on to the regulations. Agenda item 3. First, I'd like to start with an introduction to the regulatory process and some administrative notes. The proposed regulations will be addressed one at a time and in the order they are listed on the agenda. Public comment will be taken in the same order, and public comment on a particular regulation will be closed before moving on to the next proposed regulation. Before public comment is opened on each proposed regulation, I will read into the record a summary of the proposed changes. Before we begin, I want to clarify a few things. Our discussion today during this workshop will be focused on the proposed regulations listed in the agenda. We should not discuss changing our state laws, which are, of course, created by the legislature. This regulatory process will not alter any existing laws. Regulations, after all, cannot make something illegal that is otherwise legal, nor make something legal that is otherwise illegal. These regulations in this regulatory review are intended to update our regulations based on experience learned from the previous election cycle and clerk and registrar input with the expressed intent of increasing security, transparency, and accessibility. Furthermore, we are here today because of two specific statutes, NRS 293.124 and NRS 293.247. NRS 293.124 establishes the Secretary of State as the Chief Officer of Elections. It states in part that the Secretary of State shall serve as the Chief Officer of Elections for the state. As Chief Officer, the Secretary of State is responsible for the execution and enforcement of the provisions of Title 24 of NRS and all other provisions of state and federal law relating to the elections in the state. The Secretary of State, it says in subsection 2, shall adopt such regulations as are necessary to carry out the provisions of this section. Separately, NRS 293.247 states in part, the Secretary of State shall adopt regulations not inconsistent with the election laws of the state for the conduct of primary, presidential preference primary, general, special, and district elections in all cities and counties. There's a lot more to it, but those provisions are what brought us together today. Regarding this workshop specifically, though, the intent is to solicit feedback on the proposed regulations that will, 1, help clarify their intent, and 2, to gather recommendations for improvement. To be clear, this meeting is a discussion. If you ask a question, as long as it is related to the agenda item, I'll be able to answer it. Once we are complete here today, my team and I will discuss and analyze your suggestions, bringing them to the clerks for input if necessary, before ultimately making recommendations to the Secretary. If there are general questions about elections procedures, I'll be able to discuss them today as long as they relate to the proposed regulations. If there are questions that extend beyond the proposed regulations on the agenda, I'd be more than happy to set up a separate meeting at another time. To do so, please contact me via email at nvelect@sos.nv.gov. Again, that's nvelect@sos.nv.gov. So as a reminder, this is the public workshop for the Secretary of State Elections Division's proposed regulations with the following LCB file numbers. The first one is R031-25P. The second is R042-25P. And the third is R088-25P. The text of the proposed regulations has been provided. The notice of workshop to solicit comments on proposed regulations was noticed at all required locations on December 5th, and each of these documents is hereby submitted into the record. As of this morning, the Secretary of State has received written public comment from multiple organizations and individuals. The written public comment received by the Secretary of State's office is hereby submitted into the record as well, and will be taken under both analysis and consideration. Finally, I understand that discussions about elections can get intense, and I am excited about talking with you today, but I must ask that each of you treat each other with dignity and respect. Your fellow Americans in this room and listening in today may have different opinions, but they are worthy of your courtesy. Agenda item 4, the workshop regarding proposed regulation R031-25P. All right, before I begin reading the digest specific to this proposed regulation, there's a couple conceptual amendments that I want to identify and speak to as well. One moment. Okay, first, so this proposed regulation, there's a reason that we brought it into existence. You'll notice that the existing regulations in this section of NAC 293 actually talk about an existing compliance process that relates specifically to the passage of the Help America Vote Act back in 2002. When that act was passed by Congress, it requires a specific complaint process that relates to the Help America Vote Act. Since that time and since the passage of that act, quite a few things have happened. Most recently, in just a couple years ago, in 2023, the legislature approved new positions in the Elections Division that are compliance investigators that are dedicated to reviewing and investigating allegations of elections fraud. These two dedicated positions, I will tell you, work tirelessly. The two individuals in those positions work tirelessly to make sure that every allegation relating to election fraud is investigated appropriately. But one thing that we realized when these two individuals came on board was that there's not a an explanation about what exactly they do. We have a process and regulation that defines the compliance process related, again, to HAVA, the Help America Vote Act, but not just in general. And we identified that was an issue and a concern. We want members of the public to understand the compliance process. We want members of the public to understand what happens and what that looks like, and not in a whimsical manner, but something that is defined and laid out in regulation. So we have worked very closely, the members of my compliance team, along with a number of other, again, organizations and advocates, specifically to make sure that we are capturing the requirements of the compliance as it relates to investigations of election matters in a way that, again, is transparent, is clear, is fair. We have received feedback from legislators, in fact, on our proposed regulation as well. Individuals with vast experience in the compliance sphere, identifying ways to make sure that this process could not be weaponized, which is also, again, an important concern. After all, elections integrity is extremely important to all of us, as it is to you, I know. But this is a process that we wanted to make sure was written down and clear and concise as well. I will mention also again that we've received a number of different emails and otherwise providing additional feedback since the agenda has been published. Okay, so that being said, the digest for R031. Existing federal law enacts the Help America Vote Act of 2002, Title III of which sets forth certain requirements relating to election technology and administration, including, among other things, requirements concerning voting systems, provisional voting, statewide voter registration lists, registration to vote by mail, and access for congressional observers. That's all codified in 52 U.S.C., if you're interested. The Act also requires a state to maintain a state-based administrative complaint procedure, which meets certain requirements for violations of Title III of the Help America Vote Act. That's the process I just referred to. Existing regulations in compliance with federal law authorize a person who believes that a violation of Title III of the Help America Vote Act has occurred, is occurring, or is about to occur, may file a complaint with the Office of the Secretary of State and establish a process for the filing, investigation, and resolution of such a complaint. As part of this process, existing regulations require such a complaint to be in writing, notarized, and signed and sworn to by the complainant, and if one is prescribed, submitted on a form prescribed by the Secretary of State. Section 6 of this regulation requires the Secretary of State to prescribe the form for such a complaint and requires the form to be submitted to the Secretary of State by mail, electronic mail, or facsimile. Existing regulations require the Secretary of State or a designee of the Secretary of State to review each complaint to determine whether the complaint states a violation of Title III of the Help America Vote Act and complies with the requirements set forth in existing regulations concerning the filing and form of the complaint. If a complaint fails to state such a violation or comply with such requirements, existing regulations require the complaint to be dismissed without further action, and notice of such dismissal to be provided to the complainant. Section 7 of this regulation additionally requires such a complaint to be dismissed if the complainant is uncooperative in the investigation of the complaint or requests the Secretary of State to close the case or withdraws his or her complaint. If a complaint is not requested a hearing on such a complaint, existing regulations require the Secretary of State to review the complaint and any accompanying record and determine whether by a preponderance of the evidence a violation has occurred. Section 9 of this regulation, 1, requires the Secretary of State to provide a copy of the complaint to the respondent before beginning the review. 2, provides that such a review may include an investigation which includes the review of certain information and materials. 3, authorizes a complainant or respondent to designate another person to represent his or her interests in a matter subject to such review. And 4, requires, if the person designated as an attorney, the attorney to submit a letter of representation to the Secretary of State before representing the complainant or respondent. Existing law requires the Secretary of State to serve as the Chief Officer of Elections for the state and provides that, as Chief Officer, the Secretary of State is responsible for the execution and enforcement of the provisions of Title 24 of NRS and all other provisions of state and federal law relating to the elections in the state. Section 2 of this regulation authorizes a person to file a complaint with the Office of the Secretary of State if he or she believes that a violation of any provision of law that is subject to such enforcement by the Secretary of State has occurred, is occurring, or is about to occur. Sections 3 to 11 of this regulation establish the process for filing, investigating, and resolving such a complaint by requiring the complaint to, with certain exceptions, follow the procedures set forth in existing regulations for the violation of Title III of the Help America Vote Act. I do want to comment, that's an important distinction. While we are putting this compliance action and description of the process adjacent to the regulations relating to Help America Vote Act, that they are two separate and distinct processes. Existing law sets forth the Nevada Financial Disclosure Act, which, one, requires certain candidates and public officers to file a financial disclosure statement with the Secretary of State, and two, requires the Secretary of State to administer and interpret the Act and adopt any regulations or take any actions necessary to carry out provisions of the Act. Section 1 of this regulation, 1, authorizes a person to file a complaint if he or she believes that a violation of the Act has occurred, is occurring, or is about to occur, and 2, with certain exceptions, provides that such a complaint must be filed, investigated, and resolved in accordance with the procedures set forth to file, investigate, and resolve a complaint filed pursuant to Section 2. What that means is that if you remember financial disclosure statements, which are required, and this is in a different chapter, this is NRS 281, if somebody fails to file a financial disclosure statement, this identifies that there is a process to identify that to the Secretary of State so that it also may be investigated and reviewed for compliance. Again, something that I know many of the people listening on this call today and others have been involved in. This is simply codifying it in regulation. Existing regulations require a person who wishes to file a complaint concerning an alleged violation of a provision of Title 24 of NRS to submit the complaint in writing to the Secretary of State. Section 12 of this regulation repeals the provision as Section 2 has established specific requirements for filing a complaint. The last thing I will mention is that, again, while we were talking about a compliance process, I do want to clarify that this regulation also very clearly states that if there is an existing or alternate process in law for addressing a complaint, those, of course, still supersede this regulation. An excellent example is the candidate challenge process. As you may know, that we are actually a couple days into our judicial candidate filing period. It's a 2-week period, the first 2 weeks in January of an election year. If a candidate is identified as not being qualified for an office, already in statute, in both 293 and 293C, there is a process to challenge that candidate. Those would be the appropriate method for challenging a candidate's qualifications and not using this other compliance process that we've talked about. Again, want to clarify that again, many of the folks that, like I said, involved in the process and providing information about this regulation are already doing it, right? We submit election integrity violation reports. These get submitted to the Office of the Secretary of State. They come to our compliance team. They're reviewed, there's investigations, there's notifications, both to the complainant that yes, we've received it, as well as to the respondent to find out more information. Our investigators use every tool at their availability that they are legally able to. And when identifying at the end of that investigation, oftentimes it is possibly a voter education. We have complaints about things that a voter may think is illegal, but really are required by law here. Perhaps they had heard something when they lived in a different state. We also have, again, very valid concerns that are worthy of a criminal referral. The compliance team drafts a criminal referral, and we provide those to the Securities Division of the Secretary of State to initiate that criminal investigation. So again, all of these things are not new. We're simply trying to codify it for the sake of transparency and consistency as we look to future election cycles. That being said, I will now open public comment on proposed regulation R031-25P. We'll start here in Carson City. Seeing no one, we'll go to Las Vegas. Oh, perfect. Please state your name, spell it for the record, and then you may begin.
Good morning. My name is Kayla Maese, Kaylahmaese, and I'm the policy manager with the ACLU of Nevada. And you did already mention it, but we did submit a letter for the record for this meeting. I won't go into detail, but we are looking forward to working through the concerns in our letter. Thank you so much.
Thank you. Is there anyone else in Las Vegas who would like to provide public comment on proposed regulation R031-25P? Seeing no one broadcasting, can we check the phones, please?
If you would like to participate in public comment, please press star 9 to take your place in the queue. There are no callers wishing to provide public comment at this time.
Thank you, broadcasting. Okay, this time we will close public comment on proposed regulation R031-25P. We will now open the workshop on proposed regulation R042-25P. Again, before I read the digest on this proposed regulation, I want to provide an overview as well. This one speaks to the list maintenance process. The list maintenance process, I will tell you, is something that we at the Office of the Secretary of State and both our county and city election officials receive quite a few questions about. Again, I want to reassure every member of the electorate and public that are listening in that list maintenance, voter registration list maintenance, is an ongoing daily process conducted in your counties. From a big picture standpoint, the responsibility in law to maintain voter rolls falls directly onto your county clerk in 15 of our counties and county registrar in Clark and Washoe. They may delegate some of the work, of course, as members of their staff, but I do want to clarify that ultimately the buck stops with them by statute, and that is a responsibility that I know, having talked to every one of them, they take very seriously. We collectively understand that voter list maintenance, again, contributes not only to keeping our lists clean, which does everything from save the state money because there's less ballots going to individuals who have moved. It reduces the possibility of somebody making a poor decision and attempting to vote a ballot that isn't theirs. It reduces the amount of time for in-person voting. If individuals who are no longer eligible, perhaps are deceased or have moved out of the state and been confirmed through the appropriate processes, if their names are off the lists, when somebody comes in and you check in, it expedites finding your name and making sure that we have the right individual, which contributes, again, to the overall integrity of our electoral process. So voter list maintenance is extremely important and a lot of work, but frankly, it's the sort of work that we're happy and eager to do, recognizing the responsibility that we have. The state's role in voter list maintenance, the secretary's role, again, really as chief officer of elections, is one of oversight and ensuring that there's compliance. The compliance piece is important to note because there are both constraints and restraints on what can be done. When you look at voter list maintenance and you think about it from a federal and state law perspective, there are things that we must do and there are things that we cannot do. And understanding the nuance of the federal requirements and our state law requirements is something that, again, we continue to work at day in, day out to ensure compliance across the state for the betterment of our electorate and the electoral process. This regulation does relate to list maintenance. And again, we have received feedback relating to this as well, some of which has been proposed and is being incorporated, slight changes to the timelines, along with a discussion about when exactly, some certain cutoff dates too that I'll talk about briefly. But I'll go ahead now and read the digest. Existing law requires, under certain circumstances, that county clerks designate registered voters as inactive. If a registered voter is designated as inactive, the county clerk is not required to send the registered voter mail ballots or sample ballots in future elections. A registered voter who is designated as inactive may still vote in person at a polling place. Section 2 of this regulation, for purposes of determining whether a registered voter must be designated as an inactive voter after a primary election or general election, each county clerk is to mail a written notice that complies with the applicable requirements of federal and state law to every registered voter in the county for whom a sample ballot or mail ballot that was mailed to the registered voter for the primary election or general election was returned by the United States Postal Service as being undeliverable. Section 3 of this regulation requires that on or before certain deadlines in odd-numbered years, each county clerk mail a written notice that complies with the applicable requirements of federal and state law to every registered voter in the county to confirm the address of the registered voter. Section 3 further authorizes a county clerk to submit a request to the Secretary of State of the Office of the Secretary of State to mail such written notices. Section 4 of this regulation clarifies that the provisions of Sections 2 and 3 shall not be construed to prohibit a county clerk from canceling the voter registration of a person under certain circumstances, including if the person 1. dies, 2. is convicted of a felony and is currently incarcerated, or 3. requests that his or her voter registration be canceled. Now, I do want to discuss that part also before we get into the public comment piece, because again, I think this is something that many Nevadans simply aren't aware of. Federal law prohibits routine list maintenance procedures 90 days before an election with federal candidates on the ballot. But when we talk about routine list maintenance procedures, we're talking about these programs and plans that are enacted across the state and counties on a widespread sort of way, sending out notices to every voter in a county to identify who has not received them or is now being considered undeliverable. This does not prevent us, as I mentioned a moment ago, from identifying if an individual has passed away, their voter registration may still be canceled. If an individual reaches out to their county election official or attempts to update their voter registration within 90 days of that election, absolutely, that change can still be applied. Or again, if an individual is incarcerated and has started their incarceration for a felony conviction, those individuals also, we can cancel those registrations within that 90-day blackout period that's specific to federal law. This year, again, and just to highlight, what does that exactly look like? The 90-day blackout period prior to the June election. I don't want to give you the wrong date. I want to say it is March 11th. Good. I should have had more confidence. March 11th is the start of the 90-day blackout period for the June primary. Again, when you think March 11th is the cutoff for routine list maintenance processes, that's an important thing. And that's part of the reason why your county election officials have been working so hard on list maintenance as we rapidly approach that 90-day cutoff. There's a separate 90-day cutoff before the general election as well that we take into consideration. This proposed regulation specifically talks about, again, some requirements relating to and leading up to the starts of those 90-day blackout periods. But that being said, I will pause now and open up public comment on proposed regulation R042-25P. Starting here in Carson City, I see no one. We'll go to Las Vegas. Seeing no one. Broadcasting, could you check the phones, please?
To provide public comment, please press star 9 now to take your place in the queue. We have no callers for public comment.
Okay, thank you. In that case, I will close public comment on proposed regulation R042-25P. And we will open up the workshop on proposed regulation R088-25P. Before I discuss R088-25P, I want to clarify that the United States Postal Service has recently instituted changes to how a ballot is postmarked. If you weren't aware, a U.S. Postal Service postmark used to indicate the day when the mail was dropped in a mailbox, or turned in at a post office counter. Now, the USPS has a new rule that the postmark will reflect the date an envelope is first processed by an automated USPS sorting machine, which may be up to days after it was dropped off and may not indicate the actual drop-off date. The proposed regulation we're going to talk about may help, but it is still under consideration. The concern, of course, is that approximately 690,000 Nevadans submitted their vote on a mail ballot during the 2024 general election. Not all of those ballots, of course, were turned in through the U.S. Postal Service. A good number of them were, of course, brought to polling places and election official offices and dropped in drop boxes. But of those numbers, again, roughly 670,000 voters that cast their ballot, an unknown number could be impacted by these changes. And that's something that, again, is certainly concerning. And that we're looking at methods to try to mitigate the risk to the voters and ultimately having their legal votes cast and counted. And part of the reason, of course, that this matters with postmark is because Nevada law used the presence of a postmark to determine if a mail ballot was submitted in a timely manner. NRS 293.269921 states that in order for a mail ballot to be counted for any election, the mail ballot must be A, before the time set for closing of the polls, delivered by hand to the county clerk or any ballot drop box established in the county pursuant to this section, or B, mailed to the county clerk, and if it is mailed, then it has two requirements. One, to be postmarked on or before the day of the election, and two, received by the clerk not later than 5 p.m. on the fourth day following the election. It goes on to state in subsection 2, if a mail ballot is received by mail not later than 5 p.m. on the third day following the election, and the date of the postmark cannot be determined, the mail ballot shall be deemed to have been postmarked on or before the day of the election. Proposed regulation R088-25P is intended to assist in identifying when a ballot arrives to the clerk, again, to ensure that legally cast ballots are able to be tabulated. More specifically, the regulation, I'll read the digest now to explain what this regulation does. Existing law provides that if a mail ballot is returned by mail to the county or city clerk, in order for the mail ballot to be counted, the mail ballot must be 1, postmarked on or before the day of election, 2, received by the clerk not later than 5 p.m. on the fourth day following the election. If a mail ballot is received by mail not later than 5 p.m. on the third day following the election and the date of the postmark cannot be determined, under existing law, the mail ballot shall be deemed to have been postmarked on or before the day of the election. Sections 1 and 2 of this regulation provide that for purposes of determining whether a mail ballot is postmarked on or before the day of the election, the county or city clerk as applicable shall identify the date on which the mail ballot was mailed to the county clerk by reading on the return envelope, 1, the physical postmark applied by the USPS, or 2, information from a barcode or similar marking used by the United States Postal Service. Sections 1 and 2 further provide that if the county or city clerk cannot determine whether a mail ballot is postmarked on or before the first day of the election by reading such information, but the mail ballot is received by the county clerk or city clerk as applicable, not later than 5 p.m. on the third day following the election, mail ballot shall be deemed to have been postmarked on or before the day of the election. So again, I even want to highlight, as Mr. Winterhawk said in the initial general public comment, that this is something that not only are we looking at trying to identify ways to mitigate these changes from our federal partners with the United States Postal Service, but I want to reassure him and everyone else that as we consider these changes, transparency, of course, continues to be an extremely high factor. And ultimately, whatever processes, procedures, or information do get reviewed and considered relating to the timeliness of a mail ballot absolutely will be made available to the public for review as well. That is something that I know we continue to discuss and make sure that we incorporate throughout our discussions about proposed regulations. At this time, I will open up public comment on proposed regulation R088-25P. We'll start here in Carson City, still seeing nobody in the room. We'll go to Las Vegas to see if anyone has public comment on proposed regulation R088-25P. Seeing none. Broadcasting, would you be able to check the phone lines, please?
If you would like to provide public comment, please press star 9 to take your place in the queue.
Good morning. This is Oscar Williams, OSCAR, WILLIAMS, calling from Reno, Nevada. Thank you for holding these hearings. I have more of a question here because I understand this regulation allows for the Postal Service to rely on a barcode and not necessarily the postmark, or you can have a barcode and no postmark and it'll rely on the barcode. But I'm not really clear. Is the Postal Service imprinting a barcode that has this information of when they processed it? That isn't clear to me because I'm not aware that they're supposed to do that or that they do that. So it's just a question. I'm concerned about that. And if you could talk to that, sir, I'd appreciate it. Thank you.
Thank you for the question, Mr. Williams. Mark Voloshin for the record. And I will tell you again, in this position, I've learned quite a bit about how the USPS works, the nature of postmarks, and a lot of the technical workings behind it, more so than I think I probably would have guessed. But to your point, there is a number of things that the U.S. Postal Service does in the routine course of their business. Individuals, myself included, can sign up for advance notice of delivery, where you'll actually get an email of a picture of the mail that's going to be coming to your mailbox within a certain period of time. So that is but one example of there's kind of an extensive amount of information that the post office gets about mail, all sorts of mail, the deliveries, the timelines, the placements. It's a really interesting amount of, to learn about the process specifically. You may remember a few years back, there were in fact individuals who were mailing, powders to different offices across the country. And I think it's also an indication of the post office's ability for transparency and visibility that they were able to stop those pieces of mail, between the origin and the destination. So really what Secretary Aguilar has requested is that we look closely at identifying what information the Postal Service has about mail ballots to understand how we could take advantage of that to the betterment of the electorate. Again, we're speaking specifically to legally cast mail ballots and wanting to understand where they're at in the process and the timelines. If the Postal Service is now saying they simply may not be putting postmarks at all, that we want to understand how can we check to see if a ballot was in fact mailed after Election Day and should not be collected, or if it was in fact mailed beforehand to increase our visibility. And the last thing I'll mention before I ask if that answers your question or not is that whatever we learn, rest assured, Secretary Aguilar's policy is that we provide to the public. If there's new information, if there's a scanning thing or information on a ballot code, whatever we identify that would be useful and possible to incorporate, including this barcode that we've referenced and identified, we will absolutely make sure that we're providing information on that to the public. For your awareness, including going so far, and I'm certain, I won't speak for your registrar in Washoe, but I'm certain that they would want to provide explanations and information on that separately from the state too. But I believe that would be the case across the state. Does that answer your question? Mr. Williams,
Sorry, I got muted there. Hello.
Mr. Williams,
Yes,
can you
it
hear
does.
me?
It does. You
Okay.
have, for the most part, yes. Can you hear me now?
Yes,
Can you
sir.
hear me, Okay, good. Yes, your response lengthy, but yes, I understand. I don't know that the regulation kind of narrows it down. I mean, it's vague. Information from a barcode or similar marking used by the United States Postal Service is vague, and if there's no postmark, I mean, I understand the postmark can reflect the new data processing, but don't they put a postmark on everything? And if you get a mail ballot without a postmark, shouldn't that be a red flag? When did they process stuff without a postmark? Really? And you mentioned it, but you didn't say what the logical solution is when you get back. You get a mail ballot, whatever time it comes in, who knows, but it's got no postmark. And then how actually are you going to verify that? You mentioned ideas and possibilities and so on, but it isn't clear. It's certainly not in this regulation. So we need to nail that down, sir.
Thank you for the comment, Mr. Williams. Mark Voloshin for the record. So two parts I think that would be helpful. One, not every piece of mail does get a postmark. That's something that we've confirmed in working with the Postal Service and
But
something
this
that...
isn't every piece of mail. This is our ballot, man. This is our ballot. It's not every piece of mail.
concur. I 100% agree with you, and we are in perfect lockstep that every mail ballot, given the critical nature of that, those documents, that mail piece in our electoral process, should receive a postmark. But I can tell you that the Postal Service simply acknowledges that it doesn't. There's a USPS domestic mail manual. There's a document that the post office puts out. It's the Domestic Mail Manual, section 608. Specifically the newly added section 11. It defines, discusses, and includes some information about that. And because this is a federal process, we are reliant on the U.S. Post Office's definitions.
Can I ask one other thing? This is a little bit of a side issue since I've got your attention. And I've discussed this with you before. It has to do with handwritten signatures on the outside of the return envelope. I mean, this goes to, none of the regulations address that, and it needs to be addressed. So maybe I'm speaking out of turn on this one, but all this stuff relates. In our reliance on the Postal Service and the exposure of our signatures, the weakness of verifying date of mailing and so on, it lends itself to voting in your precinct and having more precincts, not vote centers. You can vote anywhere, but you can still have precincts, polling locations, and paper ballots. We don't need a central scanner. That's a complete waste of time and money. And there's just another way to do it that doesn't rely on a bunch of mail and two different styles of casting ballots, one digitized, one paper. We need a uniform statewide standard, which is paper. So if you gave us paper at the polls, more polls, we wouldn't have to rely so much on this mail nonsense and worrying about when the thing was mailed or not. We would have immediate results because you're voting in the precinct on paper, which, by the way, is helpful when the power goes out. All this technology, the power goes out, or you get ransomware like happened. I think it would affect the election. The Secretary of State seems to think the ransomware attack that happened again during the election would not have halted an election. I disagree because I went online. I was unable to access my voter history or my registration or make any changes to my registration during the ransomware attack. That happened during the election. I think it would have a major impact on elections. So I don't appreciate the Secretary of State's position on that. I'm sorry, I've deviated wildly, sir. Thank you for your time. Thank you so much.
Thank you for your comments, Mr. Williams. A couple of things I would like to address real quick. The decision in regards to the signature on the outside of the ballot envelope, again, that is a county clerk decision. So again, if you hopefully can bring that concern to your registrar for their addressing, that's not something that the Secretary of State has the ability to mandate currently. You mentioned the changes to mail ballots. That, of course, would be a statutory change, potentially requiring, BDR during the legislative session and just outside of the purview of this regulation. And then lastly, when we talk about the statewide cyber attack that recently affected Nevada, the Office of the Secretary of State has been pretty vocal about the fact that our systems were not affected or impacted. When we talk about that specifically, again, you cited the website and inability to check voter registration, the electoral systems, the processes, the voter registration databases that have our private information, the ability for a check-in kiosk, the poll pads to be used, those were also, I want to stress, unaffected. So that was the first question we asked. If this had occurred, I don't know, around June 9th of 2026, what would that have looked like for voters? And that is how we got to the conclusion that it would not have impacted negatively an election in our state, thankfully. But I do appreciate your comments, and we'll take. You also provided written email comments as well, which I appreciate. We'll take those under consideration as well. Thank you.
There are no other callers wishing to provide public comment at this time.
Perfect. Thank you, Broadcasting. All right. At this time, then, I will close public comment on proposed regulation R088-25P. And we will go to agenda item 10, public comment on matters other than the previously listed LCB file numbers. Comments will be limited to 2 minutes per person. If anyone's interested in providing public comment about a matter not on the agenda, please identify yourself and spell your name for the record. Seeing no one in Carson, we'll go to Las Vegas. Seeing no one in Las Vegas, broadcasting, would you please check the phones?
To provide general public comment, please press star 9 now to take your place in the queue. We have no callers for public comment at this time.
Thank you, broadcasting. In that case, we will close the final public comment on matters other than the previously listed LCB file numbers. Before we adjourn today, I do want to clarify that the planned regulatory adoption hearing is scheduled and agendized for January 21, also from 9 to noon. The agenda has been posted. If there's any questions about that, again, please don't hesitate to reach out to the Office of the Secretary of State. I also want, and that's the adoption hearing for these 3 proposed regulations. I also want to clarify that we have on Monday, January 12th, a different set of regulatory regulations that are set up and agendized for discussion. Again, that's on Monday the 12th, also from 9 to noon this coming Monday. And again, if you saw that and maybe assumed it was just a continuation, please take note that it's a different batch of regulations that we'll be discussing then. Otherwise, again, very much appreciate everyone's information and feedback. Yes, and I think that's ultimately it. And we will adjourn this public workshop. Thank you for your comments.